So maybe I can ask just preliminarily on this motion, Ms. Gray, there was a lot of information here that I was making sure came in. So I'm going to turn to my clerk. It all says filed the 4th, so came in the 4th.
Yes.
Okay. All right. And
We did get some stuff from Friday, though, that I just got.
today, Friday. Okay. Well, we're going to, and there's also information from September 6th. Mr. Foster, did you file anything Friday?
I don't believe I did.
Okay. Ms. Gray, did you file things on Friday?
I did. I think that's probably the most important for the court to see, just that there's been continued contact on Kevin Noah's behalf.
Well, wait a second. So Mr. Noah is asking for an order against you, and
Correct.
I ordered everybody to get things in by the 3rd, and you're still filing things, and you're expecting me to look at it from Friday that's just got filed this morning.
I was not served properly. I was not served.
A little late. Let's see, the last time we were in court was August 19th. 3 weeks ago. I'm not going to consider anything filed in violation of the court's order to have it filed by September 3rd. Certainly not information filed Friday that I can't even look at yet. It's not fair to the petitioner, and it's a violation of this court's orders, and there has been sufficient time to respond 3 weeks and 2 weeks to get that information in. And this is so we're going to go forward on what information was before the court by September 3rd. So
I understand. I did attempt to file it, but I did receive an email back from that I could forward to you that said that it was somehow the wrong. I'm sorry, you're breaking up.
Of your argument, you can speak all about that. But as to that motion, I am granting the petitioner's motion not to consider anything that's filed from either side after September 3rd. So, Mr. Foster, then, on behalf of your client, there's not an order issued yet. You're asking the court to issue one, and I'll just turn to you for your evidence, witnesses, whatever.
Yes, Your Honor, thank you. Mr. Noah did supply quite a bit of materials upon filing the petition, various text messages, as well as a statement from himself. Ultimately, Your Honor, the parties dated off and on for about 5 years. They were never married. They never had children together. And it is something they've kind of been breaking up over the last couple of years. Mr. Noah has requested that she stop having contact with him, that she no longer reach out to him. Upon kind of making that official, she's reached out to his ex-wife. She's had numerous text communications with his ex-wife, Amy. I think those were submitted in her materials as well, asking Amy, the ex-wife of Mr. Noah, to be on board with the Take Down Kevin Noah program. And ultimately, ever since breaking up with her, she's threatened to make his life a living hell. And she has been requesting that he continue to maintain some sort of medical insurance on her behalf. He's previously supplied the audio transcript or audio messages of that, with those recordings. We did provide the transcribed version of those as well. And ultimately she's saying, I'm going to make your life a living hell, keep me on your insurance, and making various threats. He says, what you're trying to do is blackmail, and she ultimately admits to that. He's blocked her from communication as well, and she's turned around and reached out to his brother-in-law, I think texting him over 80 times, calling him numerous times at the wee hours of the morning. She's done that to his son as well. Numerous calls, text messages, claiming that it's frantic and urgent that Mr. Noah reach out to him. She's reached out to his mother, various family members. It is harassing course of conduct that continues. He's asked her to stop this sort of behavior. There's been a false claim that she submitted to L&I. She's threatened to report him to the IRS, to take down his parents as well. All of these are very concerning behaviors that are offensive in nature. There's also text exchange where she has threatened suicide, which is a form of domestic violence. And we've also submitted her criminal history report. It shows, although none are with Mr. Noah, they are very concerning. There are past convictions for domestic violence, malicious mischief, assault. And these have all been very, very troubling for Mr. Noah. He's asked her to stop communication, and she continues, whether it's him or through third parties. And just the nature of the way that, like, numerous 80 text messages to his brother-in-law from, like, I think 3 a.m. to 8 a.m. in the morning.
And which exhibits are those?
Upon filing his petition, so I think it's, so within petitioner and then petitioner statement with exhibits, it's consists of 26 pages.
All right, so that's the, all right.
And
Okay, so your client statement from August 7th, and then the attachments.
correct. So a lot of the information that he provided well previously. And a lot of those various forms, if you scroll down, there's some of them are from her, and then some have no caller ID, or they're through a kind of a third-party software whereby you can send a text communication or a phone and kind of disguise your number as well. There's text messages showing it's a different number than what her regular number is. So she's using third-party software. She's using essentially third party. She's trying to get to him. She's continuing to harass him. So he is requesting that the court issue a no contact order for a 5-year period. Thank you.
And so the information, trying to see, I've got kind of March is, I have 3 transcribed. Are they text messages that are transcribed, or cell phone recording?
So I
And
believe
those
it
are
was
all in March?
yeah, that was an audio recording from, I believe, recorded from his cell phone.
Okay.
And I think they're labeled as A, B, and C.
And then the statement of your client from August 7th with all the attachments of screenshots, I guess I'll call them, of text messaging back and forth. Some of them, it's hard to tell when this happened. Some have dates. Can you help me with that? You know, these things recent in 2024.
There are some older ones. You'll notice that the various calls are from most recently, as of going into June and July, and numerous various calls in July of this year.
And Captain Crazy, who's that?
That is what Mr. Noah has labeled as Jen. So,
Okay. So there's Jen Gray, there's unknown, there's no caller ID, and then Captain Crazy. All right. These are things received throughout July. And then
right there is when you can't see what we're necessarily looking at. So,
yeah, the connection, Mr. Foster, I don't know if he can hear us, is still frozen.
I apologize. Are you there?
We're back. Okay. So we'll keep soldiering on. So, Mr. Noah, what did you think that statement to end your life meant? What did you think?
I think it's a way for her to scare me and put fear of that she's capable of doing anything. And based off of
Did it
what
work? Did it put you in fear? Did that work? Did it put you in fear?
Well, yeah, I was afraid, and but I have no explanation why, that was in a time where, I have seen her since she said that, so that's hard to say what the I I'm just now I'm more afraid of what she can do now that if this happens to where I don't know, when I come out of the house and open the garage, I kind of look outside. My kids were a little nervous after the ninth, because she said, I'm going to threaten, I'm going to take you down. And so 2 days after our initial hearing, the first thing I get's a call from LNI, just causing more problems for myself.
Okay. All right. Foster, anything else? I think I've asked the questions I want to ask at this point. Anything else on behalf of your client?
No, Your Honor.
Okay, and so then I will hear from Ms. Gray, and then Ms. Gray, Mr. Foster will have an opportunity to ask questions as well on behalf of his client. So, Ms. Gray, your response to this request for a restraining order, anti-harassment order.
I mean, I clearly do not want a protection order against myself. But if the court has to, like, I would like one and not retaliate. Like, I just feel like everything up until, I'm sorry, I'm nervous and I'm upset. I'm trying to gather my thoughts. I have a lot of notes. I do not want to leave this court without a protection order
Well, this is only about the
Pardon me?
only request. So
Pardon me?
that's before the court. Mr. Noah's request is the only case before the court, and that's what I'm trying to determine.
Oh, I can't ask one for, I'm not able to ask. for
The
one.
only, you sure can, but not today. That is not before the court. So
Oh,
you can certainly tell me what you think I should do or not do.
well,
And that's what I'm hoping to hear from you.
Okay, well, then I would like it dropped so I can ask for a protection order myself. Everything that he has said is half truths and BS and just snippets, his little clips of nonsense. I mean, the things that he's provided to the courts have zero dates. I know that I inundated the court with things, but they all are timestamped. They're all real. He has reached out my, declarations that I provided to the courts that I did get on time. My lengthy declaration. I just wanted to get it all in so there's history. My boss, my previous boss, he's saying that I'm reaching out to people and I'm being, doing things that are, reaching out to his brother-in-law, reaching out to his son. He's reaching out to a previous employer who is a professional reference. It's kind of a big deal. It's someone that I can use if I love my job, my current job. My current boss loves me. I'm doing well.
So you did file some declarations. Let me help direct you here. And I don't know who these people are. You've got
Todd Weiss is a former employer. In January of 2024, this year, Kevin took him to lunch. And because I've maintained a relationship with Todd, it's a professional situation, networking, whatever. He's constantly trying to fill roles, and I was a great employee. And
so let me ask you then. So what I hear from, and, if you can answer some of this, what I hear from Mr.
Okay.
Noah and what we've heard today is that sometime in May, he believes that he put a firm stop to this, that there was some assistance in getting property back and forth. And then in July, he receives a lot of texts, his brother, his son, his ex-wife do too. So any comment on, and let Mr. Noah and Mr. Foster talk. To extend it for a further period of time, there would be a hearing. All the parties would be before the hearing. The burden of proof, as we call it, would then be on Ms. Gray to show that the harassment would not continue, and the court would make findings and determine should the order continue for longer. But at this stage, 1 year,
Would the,
and I'm looking at the petition, Mr. Foster, I'll turn to you. I'm looking at the petition as to the request. So as to the request of what the provisions of this order should be on behalf of your client.
Well, Your Honor, I was going to request if the court would consider extending it through November 1st of next year. I know obviously he can come and seek a renewal prior to next year's expiration that the court's established, but given that he does run the haunted house business, we'd ask the court to consider extending it through November 1st of next year. If he does renew it at that time, then he does, but just consider almost a year and a few months in terms of the duration of this.
To get past that, that business that he's running, obviously after the Halloween period when that business is at its peak.
Correct.
Okay. Any other provisions here when I look at the petition that, let me get to those pages.
initially get petition through the end of,
There is no harm, no contact with Cody and Kyler, no stalking behavior, exclude and stay away from Mr. Noah, his residence, his workplace. Any changes to the requests, Mr. Foster?
As long as it has place of residence, place of employment, and business.
That's what was requested, workplace and residence.
and the haunted house business.
That seems to have some, I would do that. I don't know if there's an address or what, or a name of it, or,
Yeah, there is, it's 4-5.
okay. And then Cody and Kyler, they're both still living in your residence, or at least partially.
Actually at college now,
They
And I
both
was-
are?
yeah,
You just dropped them off over the weekend.
So they do come to visit or stay.
correct.
All right. They're members of your household then when they're not in college.
Yeah, at this point, yes, they can roam wherever they would please, they're adults.
Okay. So I will extend this out to that point. I think there's facts in this petition and in our testimony today. So out to November 1st, 2025. This will naturally expire on that day unless we have another hearing with everyone present and talk more about it, whether it will continue past that. The members of Mr. Noah's household, Cody and Kyler, are included here. Let me get to that. So, no harm, don't cause any physical, bodily injury, assault, non-consensual sexual conduct, or sexual penetration, don't harass, threaten, or stalk Mr. Noah. Don't contact him through family, through friends, through social media in any way, indirectly through third parties in any way. And the members of his household, Cody and Kyler. And their last name is Noah, Mr. Noah,
Correct.
right? And no stalking behavior, don't harass, follow, monitor, keep under physical or electronic surveillance, cyber harass, don't use phone, video, audio, or other electronic means to record, photograph, or track locations, digital, wire, electronic communication in any way of Mr. Noah and Cody and Kyler. And stay away, and you're excluded from being within 1,000 feet of Mr. Noah, Cody, and Kyler, knowingly being in 1,000 feet, his residence, workplace, and his other business located at 4548 Marvin Road, Southeast in Olympia. I think that covers the restrictions that have basis in our findings that I've made here. Anything else, Mr. Foster, on behalf of your client?
No, yeah. Thank you.
And there is no requirement for Ms. Gray to be served notice of this order. She's here. But it will be available through the court. It'll be in the court file here, certainly by this afternoon or tomorrow, and it will be available at anyone's request.
May I
and you
ask
can,
a question?
sure, you can access the court's file on your own with your Zoom instructions. And Ms. Gray?
May I ask a question?
Right, Ms. Gray?
Okay. I just was wondering how I get protection because I don't want him to contact my employer or my previous bosses or my, professional references or my friends or my family or my children. There's been constant contact. How do I protect myself?
The same way that Mr. Noah has requested.
Okay. Thank you. Thank you.
You're welcome. So that's it for this morning. As I said, this order will be in the court file for all of you to get access to. So, Ms. Gray.
The judge then carefully questions both sides about the most serious statements, especially the alleged threat to end his life and claims about making his life a living hell. These are the kinds of phrases that can dramatically impact a protection order decision. The respondent explains that many of her statements came from emotional distress and frustration during the collapse of the relationship. She even describes moments where she struggled with depression and personal hardship. But the judge shifts focus back to the legal standard. In harassment cases, the court is not deciding who is emotionally hurt more. Instead, the court must determine whether there was a pattern of unwanted contact that would cause a reasonable person to feel threatened, harassed, or intimidated. And that legal definition becomes the key factor in the final ruling. Finally, after reviewing the testimony and evidence, the judge delivers the ruling. The court finds that unlawful harassment did occur and decides to issue a protection order in favor of the petitioner. The judge points to several factors: repeated requests to stop contact, the large number of messages sent after those requests, and the attempts to involve family members in the conflict. Based on those findings, the court orders the respondent to have no contact with the petitioner or members of his household. The restrictions include staying at least 1,000 feet away from his home, workplace, and business. The order will remain in effect until November 1st of the following year unless extended by the court. With that decision, the hearing concludes, leaving both parties walking away with a legal boundary now firmly drawn between them.